Hello and welcome. If you've just joined us, we're giving everyone a moment to log on and we'll be getting started here momentarily. Hi, and welcome to another Medtech webinar. We're going to go ahead and kick things off. Today, we are talking about a new world of medtech collaborations with our friends at McDermott, Will, and Emery. My name is Nicole Owens. I'm the Director of Marketing Communications for Medtech. If you're not familiar with our association, we are a membership-based trade association that works to bolster the medical device industry, primarily in New England, through education, events like this, connection, advocacy, and awareness. I do have a few housekeeping notes to go through before I turn it over to our panel for today. Just quickly, everyone who registered for the webinar will receive a copy after it is being recorded. And we are planning on having some time for Q&A at the end of the presentation. So please go ahead and put your questions in the Q&A function on the bottom of the screen, and we'll do our best to answer them as time permits. All right, without further ado, I am going to turn things over to our moderator for today, Chuck Larson from McDermott, Will, and Emery. Take it away.
Thank you, and hi everyone. Welcome to our webinar. I'm Chuck Larson. I'm an IP partner in the practice of McDermott, Will, and Emery. I'm joined today by my distinguished colleagues, Sharon Lamb and Anissa Mohenti. I will do a brief introduction to our team, and then we will launch right into our topic for the day. I'm a self-proclaimed medtech junkie in the sense that I advise medical technology clients in all aspects of their IP strategy, counseling, transactions, and disputes in the US, in UK, and in Europe. Sharon is based in our London office and advises clients on a wide range of transactional and regulatory matters in the medtech space in the UK, EU, and globally, with a very strong emphasis in health services, digital health, medical devices, and health data. Anissa is based in our DC office and advises medtech companies in a broad range of FDA matters, including pre-market pathways, post-market compliance, CGMP, promotional practices, and quality systems. And I might add that both have spent their formative career years working in-house at their respective regulatory offices, Sharon with the NHS and Anissa with the FDA. We're privileged to hear from them today. Well, today we're going to be speaking about some very important legal developments that impact transactions in the medical technology industry. Although capital markets and M&A are rather difficult these days, there are alternatives. And in fact, there's a very vibrant and active deal-making scene going on in this area that involves collaborations, joint venturing, licensing, and other transactional and enforcement opportunities. All of this, of course, with the intent to build business and product pipelines and monetize important assets, notwithstanding the more challenging global economic times. Our goal today is actually not to torture you with an in-depth recitation of these legal developments, but rather to highlight them and give you some key trends and their potential impact on these alternative transactions that you may be undertaking. With that, I'll hand the baton to Sharon to kick us off.
Thanks, Chuck. Thank you for listening in to our webinar. One of the things that we wanted to talk about today was the kind of wide scope and nature of the collaborations we're seeing in medtech. In part, this is kind of arisen from the huge investment that has been made in software and AI in medical technologies. And an interesting feature of the collaborations that we're seeing is that they span the entire spectrum of the healthcare sector. So just a few of the examples that I've given up here, and there are multiple permutations here, are the types of collaborations that Anissa, Chuck, and I, and others at McDermott are working on every day. So, for example, commonly we are seeing two different medical device companies, so those with AI, software as a medical device, collaborating to provide a new technology for patients or for health systems, medical devices and pharma companies, so particularly where you've got technology or software that might increase drug adherence or be adopted, used by patients alongside a drug regime. Very common medical device, again, AI and software as a medical device with CROs as part of clinical trial recruiting, decentralized clinical trials and research. And that's particularly where clinical trials are happening in a patient's own home or away from a traditional trial setting. We're also seeing it as part of medicinal development, so drug companies working with Medtech to be able to kind of work out adverse incident reporting and the way that medicines are adopted and used. And then, of course, medical devices with healthcare providers. In addition, and we are seeing a significant increase in diagnostics, including gene analysis, with pharma companies and with researchers. If we move on to the next slide. So one of the things that's a kind of common feature of these collaborations is the idea of the connected patient. And this slide really just kind of tries to illustrate why there are so many diverse types of collaborations across the industry. Shows the patient connecting through their electronic health record, possibly through some kind of wearable, with their employer or with a commissioner, a payer, into researchers and developers developing medical devices or tech, and in again to healthcare providers or directly to caregivers. And what this ultimately means is that there's a complexity around these medical device and medical technology collaborations that really makes it interesting, at least that's one word, but complex when negotiating your collaborative agreement. Next slide, Lisa. When you're structuring your collaboration, we thought it would be helpful to kind of outline the kind of key principles or key points that we would expect to see, at least in an outline at the deal sheet stage. The top three, the ones highlighted in green, are the ones that we're going to be discussing today. But really important that there are multiple other facets to these negotiations that often are just as contentious as the ones we're going to discuss. And of course, those are payment, term, termination, and liability. Consumer protection, especially where you have a patient or you're kind of producing a technology to be used by a consumer. Fraud and abuse, or as we might say, incentives and inducements in the European Union and UK. And then importantly, the practice of medicine, healthcare regulation and professional frameworks. What this really highlights, though, is that there are multiple regulatory frameworks that are ongoing, and that different counterparties will come to the table with their perception of the regulatory framework that applies to the collaboration. So, for example, if we have a pharma company and a medical device company, both of them will come steeped in the knowledge of their own compliance frameworks, but they may not be so well aware of the regulatory framework that affects the other party. So often we see the first draft of a collaborative agreement, say if it's been drafted between a medical device company, SAMD, and a pharma company, drafted entirely from a pharma company's perspective. And likewise, when we're talking between a health system and a medical device company. So it just really means that it's important to be able to balance those different considerations, and hopefully we'll outline for you later how some of the points that we see and how you might address that in your own collaboration.
Okay. One of the first questions that gets asked at the beginning of a medtech collaboration, or really any transaction in medtech for that matter, is, do you have strong IP? This is highly relevant, but not everybody fully appreciates the implications of that question. It's more than hoping you have enough of a story to convince the next round of investors to put more money in the company. What you really mean is, and what is really meant when this is asked, is assuming your technology is excellent and the collaboration product is good for patients and is going to make a significant difference in the market, can you rely on the IP to defend that business from the inevitable competitor attack? And that's going to be against the product, the IP, the market you build. How does the market actually value that IP position? If you look back over the history of medtech, and look at all the really good stuff, and you start with stents and heart valves, orthopedic implants, pulse oximetry and imaging, and even more recently into the spine stem and blood pump and robotic surgery areas. The good stuff that really makes a difference in the market, you'll see that the question is a matter of if, but it's a matter of when are you going to have to defend the technology in IP infringement and invalidity proceedings. We could spend a whole symposium, a full day on this, talking about how you set up a strong portfolio or defense. And as a medtech junkie, there are not very many things I enjoy speaking about more than that. Having been through a number of the battles in these areas, it's quite, I'd love to talk more, but today we're going to focus just on that second question about the value of the IP and some trends, 3 key things that are happening that's driving that upward. So the first one, the first trend is that we're seeing a number of large patent infringement awards. You can go to the next slide for this one, coming from the US courts. In 2022, the top 5 patent infringement verdicts, just the top 5, rolled out over $2 billion in damages awards from the juries. And 2 of them, the ones highlighted in green here, the Illumina and the Ravgen LabCorp cases, were in the medtech area. DNA sequencing technology and neonatal blood testing technology. This is pretty substantial. There's a lot of cash for good technology that ends up in a fight and is able to be defended against competitor attacks. This is where the value, the dollars are driving. Let's go to the next one. This is trend number 2. On the heels of this, and rising over the past few years as well, as a rise in what we call litigation financing. This is new capital that's being made available for enforcement of patent campaigns by smaller patent owners. And now this is, you have to admit that talking about patent litigation is not kind of the place deal makers in medtech like to be talking. You'd rather be talking about building products and markets, but the reality of it is this is coming. This is in the market, and this is impacting significantly what the value of the IP will be and your ability to actually deploy it in the market to protect your business. These kinds of financing vehicles are becoming extremely popular. I think it was over 13 billion committed commercial litigation wide last year in the US. It's non-recourse, non-dilutive funding. It's done to fund licensing and enforcement campaigns for companies, smaller companies that have patents and IP that's significant, related to significant products for them to gain returns on it. It's upfront capital is also available. We're seeing a dramatic utilization in these vehicles, 670 million committed last year just to fund patent litigation, 800 million the year before, and we're projecting it to be somewhere in the middle this year. So about $750 million a year recently being delivered into this market. Half of it now to small companies. 80% of in-house counsel recently surveyed said they're considering using this vehicle. And when you take into account that there's a shortage of investable assets, good patents to cover good technology, you can just get the view that this is a rising market and the valuations and the opportunities are going up. So number 3, to the next one then, is a competing marketplace altogether that's firing up in Europe, and it's going to start in a couple of weeks. This is what's been colloquially known as the UPC, or the European Union's new Unified Patent Court. This is the establishment after 30 years of negotiation. The EU has agreed to establish a single patent litigation track to cover patent litigation in all the member states that ratify this. 17 countries now, and others will follow. This is designed for patent owners to be able to take their patents and get meaningful relief. It opens, as I say, in June 1st. And there are a couple of, on the next slide, I've highlighted some of the key kind of high-level takeaways. Number 1, this is going to work swiftly. It's a year-long procedure. All the issues are going to be heard. From patent enforcement standpoint, infringement and validity. Injunctions are going to be, we expect to be par for the course in this tribunal and across the EU. And there's a strong incentive that I can talk more with you about if you don't believe me, but this is pointed toward a strong venue for patent owners to get meaningful relief in Europe. This is taking serious shape, and it's increasing in terms of its impact on the value of European IP assets. So if we consider that, then the next slide, what are we expecting to see? Well, we're going to see an increased enforceability of EU patents. It's not often the case in a medtech due diligence for a transaction that you really think that carefully about the European side of the house. Usually it's a US market-based focus, and the US IP is kind of the litmus test. But now you have to be thinking carefully about the European side of this. The valuations are going up, the enforceability of it's going up. You're going to see, I think over the next 3 years, you'll start to see its impact carry back into the US and even the UK courts. They're going to have to keep pace with this. The overall effect is, of course, an increased patent portfolio valuation, especially when you take into account the rising damages coming from the U.S. courts and the litigation financing pools. All of that adds up to say there are some significant things you're going to have to think about in the collaboration context, from a due diligence and a transaction standpoint. And here are some highlights. I'll leave you with these, but we can speak, happy to speak offline about more of this if you have specific concerns. But you're going to have to start thinking carefully about the substantive scope and strength of the underlying IP assets, and the European assets are going to have to take a front row seat. That's where the best enforceability and the best value out of the IP at a much lower cost and much faster process. You'll see it in Europe. And so now is the time to be thinking about the assets themselves and whether you've got enough strength and enough scope to those to do the job. You'll have to look at the ownership and the enforceability rights according to the contract. And we always lay out lengthy provisions for who gets the first right, who owns the IP that arises out of the collaboration, who gets the first right to enforce it, who makes the decisions about prosecution, and in the case of Europe, who will get to decide whether to opt the patents out of the new unified court. All of these provisions should be in your contracts already, but you'll want to double check and make sure that they are laid out specifically to address these issues, because this will be significant over the course of the coming years. Reps and warranties and indemnification. There are stock provisions for this. There are typical ways that risk is managed and allocated. You'll have to think about the overall risk, taking into account the rise of the value of the IP and the European side of this as you negotiate these. Infringement risk in Europe is going up for everybody who's doing business over there. So you have to be doing the diligence on it. You're going to have to be contracting around the risk allocation in a way that takes that serious. One of the things that companies often do on the US side is they'll do a freedom to operate study to scope out the European estates of their competitors, figure out what patent risks they face, lay out a plan to evaluate them and do something about them, resolve them in some way, and use that as a way to prepare for due diligence and for launching into new projects. Now you have to take into account the European side of this. It's not very common that companies launch a product or develop a product in a European-based collaboration or in any collaboration that really takes the EU patent estate seriously of the competitors. But now's the time. You're going to have to start doing that because, as we say, as I've shown here, and there's a lot of data to back this up, and I have lots more I could say about it, but there's the risks are going up, the opportunities for patent owners are going up. The ability to sort of put forward an IP estate that's got more value, and more enforceability, and more marketability in the space is now probably it's trending toward being as good as it's ever been for US medtech. So this is the takeaway. This is, again, at a high level, the business takeaway is as you see it here. And again, we'd be happy to talk more about this in specific detail if anyone has questions. With that, I'll pass the baton back to Anissa. You might still be on mute.
Yep, I'm still on mute. The challenges of trying to advance the slides and also deal with my lack of anyway. So we're obviously focusing on collaborations that involve medtech, and in particular, collaborations involving medical devices and software products. But medtech collaborations typically straddle research laws and regulation, sometimes pharma and medicines regulations, particularly in the space of digital therapeutics, and thinking about how we use data to advance the regulatory science and marketing applications for pharmaceutical products, and then healthcare provision itself. But we will spend a few minutes talking about regulatory updates both in the US and the EU and UK, not because we're going to do an in-depth regulatory update, but because they might be relevant to collaborations and reflect a bit of a sea change. So whether you have a medical device is becoming an increasingly complicated question, particularly in digital health collaborations and with software. So, the purpose of this slide is really to underscore that whenever you've got a collaboration involving medtech, you really should start with that threshold question at the outset as to whether what the product that you have is a medical device, or, at any point in the future might implicate medical device regulations. And that should also include thinking about, how you gather data and how you plan to use data in the future. So in the US, a medical device is a product that's intended for the use in diagnosis, treatment, cure, mitigation, or prevention of any disease or condition. And that's a very, very broad umbrella term. So while FDA has regulated software for quite a while, for example, software in hardware like pacemakers has been regulated for as long as FDA has been around, all software that is intended to treat, diagnose, prevent, cure, or mitigate a disease or condition could be regulated. In 2016, Congress passed the Cures Act, and what this did was carve out certain types of software from the definition of a medical device. We're not going to go into all of that in great detail here, but suffice it to say, it is important to run that analysis on the front end, but also be very cautious, because what I see a lot is companies make the assumption that they automatically fall into one of the 5 categories that was excluded without kind of doing the detailed analysis to make sure that either they're not within those categories based on the nuances of the features and functionalities, or that they might be a different kind of regulated medical device that, has pre-existed and has its own classification regulation and may otherwise be something that you need to think about from a collaboration standpoint in terms of regulatory responsibilities and apportionment of those responsibilities. The Food, Drug, and Cosmetic Act, when you're doing that analysis, it has to be read in conjunction with those interpretive guidances that FDA has issued. And that's what I was alluding to a moment ago, which is, the statutory language is about as clear as mud. And so you really have to go and look at how does FDA construe the concept of general wellness tools? How does it construe clinical decision support tools? And I'll go into that in a bit more detail in a second. But, mobile apps, desktop platforms, the platform is actually somewhat irrelevant. Any app or software tool that ticks one of those 5 boxes that we talked about, treat, diagnose, prevent, mitigate, cure, even if it's meant to be used as an adjunct to therapy, or if it's meant to provide a recommendation that ultimately, there's an intervening learned intermediary. FDA doesn't care that there's a learned intermediary. And I think that's something that trips up a lot of folks, is that there's a notion that, well, if a provider is going to sort of ultimately make the judgment call in terms of the patient treatment or diagnosis, then my product isn't regulated and I don't need to worry about FDA or any of these other regulators. And that's simply not true. I'll spend a couple of minutes talking about clinical decision support just because it is a bit of a hot topic right now. FDA issued a new final guidance document about 6 or 7 months ago that has sort of resulted in a reevaluation for a lot of companies in this space. But clinical decision support is simply software that intelligently filters or presents at appropriate times, patient or person-specific information intended to enhance health or healthcare. And where we've seen a lot of software products come closer to the line based on the last guidance is in software products that triage, rank order, help sort of funnel patients more effectively through the healthcare system. A lot of those products under FDA's prior draft guidance documents, and I'll actually advance the slide, might have been, credibly under enforcement discretion or non-device, but, based on FDA's most recent guidance, they're a lot closer to the line. And so one factor to consider when you're looking at the clinical decision support guidance is if you want to keep your product outside of FDA regulation, in other words, you don't want your product to be a regulated medical device, you should make sure that aligns with your IP strategy, because there are scenarios in which it may not be feasible or desirable to stay out of FDA regulation while maintaining and protecting your IP, because one of the factors the FDA looks at is that software is sufficiently transparent. If it's a proprietary algorithm, is there enough information that you're putting out there for a healthcare provider to be able to look under the hood and see if they agree with kind of the basis of the recommendation? And that's not always compatible with your IP strategy. And again, I would say FDA doesn't necessarily care about your IP strategy. So that's just something to keep in mind. This slide just illustrates kind of the outcome of the Cures Act and the various FDA guidance documents. And the takeaway here is that FDA is still, at the end of the day, only regulating a small subset of software functions that mimic or expand diagnostic and treatment modalities, but you still have to run that analysis because you might be surprised to learn that a tool actually is regulated. And then we'll get to, in a few moments, kind of the implications of that in a collaboration context. I'm going to skip over this for sake of time. One other area I want to talk about is the challenge of artificial intelligence and machine learning. FDA is still trying to develop a framework, particularly for learning, machine learning and AI-based algorithms, because while FDA has at this point cleared or approved, I think, upwards of 500 software tools that employ AI in some form, I believe that all of them, if not the majority of them, employ a locked algorithm. So they don't have the continuous learning aspect of it where it's automating changes. In 2019, FDA issued a white paper to kind of talk about the direction it wanted to go, and then an action plan in 2021 about the direction it wants to go. But, we still have yet to see a lot of clear guidance in this space. But, at the end of 2022, the omnibus, the big federal funding bill, authorized FDA to approve what's known as a predetermined change control plan. And that change control plan is, basically a way for a developer or manufacturer to put in front of FDA the planned changes that, the software will have. Once it gets to a point that it exceeds that predetermined change control plan, that's the point at which companies would have to come back and get a new clearance or approval. We have yet to see, obviously, how this will all play out in practice, because sort of the challenge is, what is the threshold for a modification that requires pre-market review? Obviously, small incremental changes may not be enough to warrant a change, but how are we going to define it? And the guidance sets forth on the right-hand column here, you'll see 3 elements of the application that should be submitted. And the reason that this is important in a collaboration context is that this is going to be a whole new section of a marketing application. The submitter, so whether that's a manufacturer or developer, will need to obtain access to the right data and information to be able to satisfy this regulatory requirement. So, when you're doing a collaboration, you want to make sure that you have access to the underlying data, to the proprietary information, because you're going to have to put that in front of FDA, or you're going to have to give FDA some kind of right of reference so that FDA can go examine it on their own. And with that, I will turn it over to Sharon.
Thanks, Anissa. So as Anissa said, when we find collaborators working together, one may already have a medical device, perhaps certified as a medical device. They may be working with somebody else. And the output of that collaboration may be to create something new. And Anissa has kind of really ably kind of explained the rules that apply in the US as to whether or not the output of that, or indeed the one or other creations at the outset, are already a medical device. On one level, the language in the EU, and it's the same in the UK, broadly speaking, is very similar to the FDA stance. The difference, I would say, so it kind of gets to a similar place, but it takes a slightly different starting point. First of all, there are 2 points. It's a kind of software is defined as a set of instructions that processes input data and creates output data. So a key point in working through your collaboration is whether or not the tech that you're creating is performing an action on data. And that would typically be wherever there was any kind of algorithm or analysis of underlying data that produces a result. If you simply have kind of plain kind of reference software, so nothing is done, it's simply a kind of list of kind of available resources to a clinician, or if the information is just stored or it is processed through kind of an email system, then there's no action on the data. So for example, anything that would just be a storage, that wouldn't be a medical device. The other point is it's software intended by the manufacturer to be used alone or in combination. So it needn't be the technology just on its own. It may be two medical devices, or in fact, the collaboration may create a new medical device if the new medical device has its own intended medical purpose. And just I'm going to move on to the next slide, which talks about the broad framing of a medical purpose. The point of this slide is not to kind of look at every single word here. It's just to kind of flag that it's a very broad intended purpose. And it can be anything from diagnosis, monitoring, predicting, so looking at symptoms and identifying whether there's a risk that a person may have a disease or may be prone to a disease in the future, treatment or alleviation of disease, including, and then later on, anything else that would more classically look and feel like a medical device. Now, we commonly find that medtech collaborations land up in one of the first two bullets there. So they're either indicating or attempting to support patients, or to triage or to address, to treat patients. If we move to the next slide, Anita. I've extracted this from the EU MDCG guidance about whether something is a software, is medical device software, simply because it's a helpful checklist. It goes through the points that I've already outlined, with kind of three being the important thing. So is it software? Normally that's any kind of algorithm or program. Typically standalone, but it could also be an accessory, so software that's included within a medical device itself. So that might often arise where you have a technology company with an algorithm or AI accompanying that on an electronic patient record or alongside a drug, or in fact two collaborators coming together. The third is the point I said, it's is it performing an action on data? So are we doing something to it? And the principle here is that, and this is the key point for decision support software, and decision support software would usually be a medical device where it applies automated reasoning, even a simple calculation or an algorithm or a more complex set of calculations. And an example of this are kind of dose calculations, symptom tracking, or clinician guides to help clinicians make decisions. Most of those will fall within the scope of medical device regulation. Occasionally you may find decision support software that doesn't perform an action on software, for example, where it was just a kind of reference guide. But it's not enough to say, my software is not a medical device, because ultimately the clinician makes a decision. The really important question is whether the clinician is able to see behind the technology, to be able to understand all of the calculations that have been made on the data in order to be able to kind of question the conclusion that's been given. And because in most cases that's not possible, or the algorithm goes beyond something that's very simple, like a very simple calculator, we would typically reach the conclusion that any output was, that functionality was a medical device. The last one is it the action for the benefit of an individual patient? And we contrast that to if you're having a technology that's been put in a hospital system, for example, to predict length of stay across a hospital. So not being used for the treatment of a particular patient, but might be used, for example, for bed management software. And then we kind of have the final conclusion, is it a definition in accordance with a medical purpose? So does it have one of the intended medical purposes? Anissa, do you want to move one slide? And this is just a summary of the kind of points that I've already discussed. And these are examples. Everything that's likely to medical device has already been found by regulators in the UK and Europe to be medical devices. The takeaway I'd like you to come as soon as you're producing something helpful for a patient, it has software and it's to do something for their treatment, you're more than likely to be in that category and would need to be certified. All right, so let's come on to what that means then for your collaboration. Anissa, do you want to kick off here and then I'll kind of finish there?
Sure. Yeah, so, it's important to have clear sightlines on who holds or who will hold regulatory approvals, certifications, marketing authorizations, those sorts of things, and who will primarily or exclusively interact with the regulators. This should be, delineated in an agreement on the front end, and that goes hand in hand with doing that regulatory analysis on the front end to assess whether you will have a regulated product or whether the uses of data or research applications might implicate different regulatory controls. Similarly, and I alluded to this before, but it's important to ensure that there is appropriate access to data and that there are audit rights, and that includes for the governmental and regulatory authorities. So if you're submitting a marketing application to FDA or someone else, and you need to make sure that your agreement accounts for the fact that FDA may wish to examine, look under the hood, ask questions about the data and its sort of underlying methods and collection and that sort of thing. And if you're not the party that's sort of managing the data directly, you need to make sure that you've got that accounted for in your contractual relationships.
So all of everything that Anissa said, I should say, these apply, the points that Anissa made apply just as much in the US as they do globally. And so coming on to this one is this point in the middle, to understand whether, in addition to your existing certifications, approvals that you already hold. So this is a common misconception. You may have two softwares, medical device players coming together to collaborate to create new software or to ensure that their software works together as an integrated tool for patients. In that case, particularly in Europe, and I think the similar applies in the US, the person who gives or places the product, the combined product together as a system on the market or provides it to the user also has to do an additional declaration that the two medical device technologies, work together as a system and are safe and are validated together. And that step, that kind of system declaration, is commonly forgotten when we see collaborators working together. Both are very kind of caught in their own, this is what I've got, and I've got my medical device, and I've got my medicine, and they've forgotten that when you're putting something together, you may create something new that is in itself requires validation. The next question is, and this is often quite a thorny discussion between collaborators, is who's the person in the collaboration who's responsible for placing the technology on the market? That's European speak, but it's very similar principles in the US. Who's the person who's going to be facing the consumer or the user of the technology? And clearly this goes to kind of branding and labeling as much as it goes to the medical device responsibilities. But the person who's giving that technology and has the labeling responsibility is ultimately the person who's going to be responsible to the regulator. So we may, for example, find we've had a recent pharma medical device collaboration where we found that the pharma company wanted to present all the technology in their own name alongside so they had their drug and there was a new technology, and they wanted to be the one who kind of faced up to the patient because they wanted it to look like their technology. Well, the point of that was that as soon as they'd placed their name on the product, they assumed manufacturer status. And although they had a highly compliant regulatory function for medicines, they weren't kind of geared up to deal with the medical device regime in the same way. And so that led to quite a rejigging of the collaboration in order to ensure that the person best placed to deal with the medical device regulatory rules would be the person who was named on the product. And I would also kind of mention that it's important that you work out, when you are coming from different regulatory frameworks, what information needs to be provided with respect to the other person's product. So say you put your hand up and said, oh, I'm going to be the one that kind of places the product on the market. It's going to be in my name. You also have to remember that there may be other regulated information that needs to be provided to the user, including instructions for use. There might be drug information or sheets that need to be supplied at the same time. What I'm sure Anissa and I would both recommend is that you take really careful early analysis about liability and claims. What we often see is kind of a back-to-back indemnity. You're responsible for your product, I'm responsible for my product, and we'll let the balance be fought out in courts about who's responsible. But often in these collaborations, one person has taken a stronger role in the regulatory lead and may have to interface with the regulators. And so I would just to make sure that when you're drafting your liability and indemnity provisions, that you've carefully thought about whether you are able to exclude liability when you will ultimately be on the hook to a regulator, and how that plays through to your drafting. And then on a similar point, what will the impact be of claims where claims are made where it may be contributory negligence, and who will be responsible for adverse incident reporting and recalls? Does it mean that the whole product needs to come off? What will that do for your collaboration? And will that be a breach, or will that be something that you remedy through the course of your collaboration? Should we move on to the next?
Yeah, so you should make sure that agreements reflect the appropriate compliance with law's provisions. Obviously, I'm going to speak to the sort of US and FDA side of things, but Sharon, feel free to amend or append. But if you're thinking about data, do you need to consider 21 CFR Part 11 compliance or compliance with FDA's good clinical practice requirements? If you're thinking about future acceptance of data by a regulator, you have, fraud and abuse considerations, as Sharon mentioned, adverse event reporting and recalls, thinking about compliance with the investigational product regulations. So all of these things, you have to think about the product and the future intended kind of commercialization pathway. And one thing I will say is I've seen collaboration agreements get incredibly unwieldy. I mean, 30, 40, 50, 70 pages. And I tend to think that sometimes if you can't solve for all of these things on the front end, you should consider, putting in your collaboration agreements, placeholders for ancillary agreements that you can negotiate later when some of these things are more fully baked. So I don't mean to suggest that you have to solve for all of these things on the front end, but you should certainly be at least planning and preparing for the possibility of needing some of these kind of ancillary arrangements. And to that end, providing for post-market or ongoing compliance. So in the case of medical devices, you might want to provide for future quality agreement negotiations or other notices or prior approval provisions as it relates to quality systems and changes. One other thing is, do you want to explicitly call out things that go beyond things that have the force and effect of law? Because it is an agreement, it's a contract. You can agree to adherence to guidances or other best practices that may not be required, but may be prudent and may be an industry standard or norm. And then, of course, agreements should really provide for reasonable cooperation between the parties, because, while there may be things that you can't sort of insist that someone else do, the facilitating the provision of information and facilitating compliance, you want to set that expectation on the front end that the parties will sort of assist each other in furtherance of kind of this ultimate goal of both parties succeeding. So put that in your contracts on the front end.
And to your point about what we would do and how long these documents are getting, we are seeing that a lot of collaborations now adopt the pharma model of collaboration, so a quality agreement with a checklist and a summary at the end. And I think that's something that's probably quite new in medtech collaborations, probably adapting from good practice in pharma collaborations. And to continue with the checklist of points that we would see, what's really important is, do you need to be able to audit your collaborator? And if so, is that at your cost or their cost? And if they're using supply chains that may affect your ultimate product, what right do you have to move down the supply chain for that, so you've got the visibility about what's being provided to you. Likewise, on government inspections, there's nothing worse than discovering that your collaborator has been inspected and you didn't know about it. And similarly on regulatory submissions. Now, there's clearly an interface here, and I'll allow Chuck to kind of chime in here. But often the regulators expect a lot of information up front, and you do need to be careful to make sure that when you're preparing and circulating this information, you've already given good thought to your IP strategy. Chuck, I can see you've come off mute. Do you want to mention?
Well, it is worth noting that this is not a trivial point. This is if we talked about earlier about getting hit with patent infringement litigation in the medtech space. Often exhibit number 1 or exhibit A is the regulatory document, the submission you made to the regulatory authorities about how your product works. And it's not per se, it doesn't necessarily you're admitting infringement by doing that, but it can be very difficult if you're laying out in your regulatory documents that the things that you have to do to practice your product happen to coincide with what the competitor patents lay out. So it's important to be cognizant of the IP so you get it right when you write the regulatory documents. Make sure the submissions are consistent with your defense strategies, your patent analyses that you've already hopefully done.
Thanks, Chuck. I mentioned indemnification and product liability earlier, but I think what an important point to bear in mind is ensuring that your collaborator has the right level of insurance and whether you're named on that insurance, particularly where there's product liability points. And then finally, a really knotty point is who gets the right to publish and who gets the right to kind of claim the benefit of the collaboration, and whether that's something that's subject to a veto right of the other party. Should we move on? So the most common question we get is, who owns this data and how can it be reused? And if I had a dollar, or if I had a pound, or indeed a euro, for every time I was asked that question, I think would be on holiday today, but I'm sit here with you. The thing I just really want to emphasize here is that because of the nature of global medtech collaborations, we find that there are multiple privacy laws that apply, and that the parties who come to it are coming with a very ingrained perspective from their own regulatory environment. And that can sometimes counter the law that applies, especially where things are international. But so I've mentioned this before, but regulatory frameworks may differ by product, but it's really important that privacy may not always trump the requirement to keep information for vigilance purposes and the requirement to report incidents and deal with recalls. And whatever you do with the data, you do need to know that even if the other person, and I'm using this in inverted commas, owns, because I'm going to tell you why no ownership of data in the European Union and the UK, but it's really important that you have access to that data to be able to deal with the regulators' questions. The key takeaway here is that it really are multiple overlapping and sometimes contradictory regimes. For today's perspective, we are not focusing on HIPAA, and I would welcome an opportunity to speak to you again about the state rules in the US, which are not always consistent, and HIPAA, where you're working with the health system. Today, we're going to focus on the GDPR, which largely kind of reflects the regime in the EU and UK, but also is now kind of reflected in many other countries. So if your product is being used internationally, this is a kind of good benchmark to have your heads around before you start. Do you want to move to the next? So the first point is that nobody owns personal data. The data subject is the kind of is the person whose personal data belongs to. Instead, we have a concept of controller and processor, and if you've done any work internationally or in Europe, you will have some familiarity with this concept. A controller is more like a trustee of data. They're the person who are responsible for the safe handling of the data, for letting the data subject know about what they're doing with the data, and they may be able to keep and reuse it. A processor, on the other hand, is simply I like to call them a postbox, or sometimes a postman or postwoman. They're simply holding and transferring the data on the instructions of another person, and they are not able to reuse the data for their own purposes. They may only do what their controller tells them. The second important takeaway here is that health data is very widely defined. It's widely defined as data concerning health. It is not just patient records or patient identifiers. It includes inference data. Now, interestingly, McDermott just ran one of our most popular webinars of all time, which is there health data and tracking technologies? Something which is surprising to us European lawyers, because of course we would have answered, of course that is health data. And in fact, there's just been a big fine by the French Data Protection Authority 5 days ago on cookies, saying that they were health data. So I just want to remind you that there's a wide level of data in your system and in your collaboration that would be health data from the GDPR perspective. An important point here that I wanted to mention for those who are working in a regulated space, you need always a lawful basis, such as legitimate interests, but you also need a condition under Article 9 for special category data, so health data. And an important point for those who are regulated and who may require the data in future is that public health is often used or commonly used for medical device companies or pharma companies, meaning that you do not always need consent. I often hear our US clients saying, oh, I'm going to default to gold standard. But the issue about using consent when you're a regulated player is that you may not be able to remove the data if consent is withdrawn. And so in fact, under European standards, express consent is not necessarily the best basis to proceed if you require that data and that consent can be withdrawn. Just moving to the next slide. I'm conscious of time, but I think these takeaways are extremely important, and they are not limited to a European side analysis. They're important wherever you're working in the world. It's really important that you understand what you're bringing in, what you're ingesting, and what is going to be transferred. I mean, I know that a map of data is one of the most tedious tasks of a collaboration, and it's often the thing that's left for the very end, despite the fact that the first question was who owns the data. Often people don't know what's actually flowing through their systems. It is really important to understand international transfers and when data is subject to GDPR. It can happen even if you're thinking you're both collaborators are in the US, it may still be subject to GDPR if the product's been placed on a global market. Do understand the different regulatory frameworks that may affect controllership, where it's not okay to say, well, I'm a controller and they're a processor. If you both need the information for your own purposes, you may be independent controllers or joint controllers. Now this third one, I actually cannot emphasize enough. Understand who your collaborator may be using as a subcontractor and processor. Over the last few years, we've seen collaborations kind of come and go, and data has been held down the supply chain. And at the end of the agreement, there's been a question of, well, I don't hold that data, but it's been stored by supplier X or supplier Y, and you have no rights to that, with ransom payments being being demanded in order for the release of data. I would really kind of challenge you to kind of think who else is using it, where else is my information going. Understand the security and cybersecurity protections that your collaborator will put in place, including the interface and links with your technologies. This is crucial because if the technology is going to operate live and be a link into your system, then that obviously increases the cybersecurity risk of your own organizations, particularly where you may be holding great databases of other information. And I would review the technical measures perhaps on a kind of audit or an investigation on a regular basis. And so finally, and just to say, of course, the data is a very wide term. Next one is make sure you understand why. It's the next one, Anissa. Make sure you've understood all the legal basis. Do not default to consent. I understand it may be gold standard. I also understand it might be needed for other reasons if you're doing a clinical trial or if you're providing health services. Please be careful to separate the reasons for which you're collecting it. Make sure it's really clear that if you're going to be providing data to your collaborator, that you've told the data subject. Be really careful when relying on anonymity or de-identified HIPAA standards, and document any rationale for why you consider that information may not be personal data. And then finally, it's really important to consider the national law supplements and the specific requirements of health law, medicines legislation, and professional obligations. Now, these 3 slides I've kind of gone very quickly through it. We are obviously delighted to talk about that in more detail, and we run detailed sessions on health data if that would be of interest in for future sessions. Left a few minutes for questions, and we are obviously very happy to take any.
All right, fantastic session. So we do have just a few minutes. If you have any questions, please put them in the Q&A function at the bottom of the screen, and we can answer them now.
Seems we answered everything, Nicole.
That was the intent, wasn't it? We would lay it all out in such clear detail that no one would be
No question.
confused in all respects.
Chuck, I don't know if you saw one did just come in.
Oh, okay. I had there's a third. Okay.
Is it you?
There's a question here about, is there any change in best practice for filing in the EU? And I'm taking it that means IP filing, but that could mean other filings too on regulatory side. But on the IP side, there are some best practices, and there is you have to take into account what your market is, and you need to take into account whether your IP is the kind of IP that you think someone's going to infringe. If it is, then there's strategies you need to take to opt it out of the new system or not, but be prepared for defending it in the new Unified Patent Court. So it's a fairly detailed assessment that you can go through to figure out whether it's right for you. The question, though, the overarching question is someone out there going to be using your IP and you want to stop them? If so, that's going to take you down one path. If not, you could do the default approach that many companies take, which is to simply opt out of the system and stay on the sidelines. That's a hard question to answer on the fly here. We'd have to talk about it in detail, but the short answer is yes.
Wonderful. Well, thank you again, everyone, for joining us today, and thank you for your expertise. It was really very interesting session. Everyone who did register for the webinar will receive a recording of this after. And I encourage you to go to massmedic.com/events and check out all the upcoming events we have going on. And I'd like to say thank you once again to our sponsors for today's webinar, McDermott. We cannot put on great educational content like this for our members without support from sponsors like you. So thank you. Have a great day.
Thanks, everybody.